and 95.3 FM, W237BD Boca Raton, the Health and Wealth Radio Network.
There's an unwanted guest in thousands of homes. It's opioid addiction. Think it can't happen to your family? 20 to 30% of patients prescribed opioids for chronic pain will misuse them. And about 80% of people who use heroin began by first misusing prescription opioids. Drug overdose is the leading cause of accidental death in the U.S. Don't be afraid to talk about it, because help is available.
This Beasley Best Community of Caring message is brought to you by Talk 1470 and 95.3 FM WNN.
If you're tired of losing money when the stock market goes down, then feel you're not making enough when it goes back up, take an investment class at Online Trading Academy. For 2 decades, Online Trading Academy has taught over 200,000 students how to time the markets, how to pick the right stocks, how to limit risk, and how money is made in up, sideways, and down markets. All instructors are certified, currently trade, and profitable. They show you what they do every day with stocks, options, futures, forex, and now Bitcoin. So if you're tired of losing money when the market goes down, then feel you're not making enough when it finally goes back up, call now for a pair of tickets to a free sample half-day class in Broward or Palm Beach and see for yourself how educated investors make trades. Online Trading Academy, the leader in investment education. Call 954-668-2510. 954-668-2510. 954-668-2510.
Go to your app store and download the WNN app on your Android or iPhone. And never miss a Talk 1470 minute.
The opinions expressed on the following sponsored program are strictly those of the host, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors. Welcome to the Ask the Experts show with local celebrity host Steve-O. Sit back each week while Steve-O educates you with live in-studio experts, such as lawyers, doctors, home improvement, and financial experts in their field. Call in and have your questions answered each week at 888-565-1470. Now, here is Steve-O with today's expert in their field.
Hey, good afternoon. Welcome to the K. Bender Rimbaum Hospital. We've got one of the senior partners here who he calls it foot.
I said I had a surgical procedure.
Surgical procedure. Bro, when they cut on you, I don't care what, it's surgical. So we've got the K. Bender Rimbaum law firm with us. This is the first Thursday of the month, so that means the K. Bender Rimbaum Ask the Expert show. And we've got both Michael and Robert with us today, so you can actually start calling us. You can call us at 888-565-1470. And you know we're on FM now, too, 95.3 FM and 1470 AM. We'll be taking your questions throughout the hour. I got to ask a question. You guys won an award.
Congratulations.
You're looking at me like, what? What's he talking about? You won an award. Florida Community Association Journal Award for the 5th consecutive year.
And their highest honor, the diamond.
That's pretty hot.
That's a vote of people out there, right?
See, you just expected. You're just sitting back there.
No, not
5th year running.
It's a big deal.
No, it's not. Yeah, but still, it is.
Tell us about the award.
Well, the Florida Community Association Journal, which is a great publication for the community association industry, each year they do a readers poll. And these are presumably, they are those who are voting are interested. They are board members. They are industry leaders, fellow vendors, and they have different tiers. Diamond being your highest level, and I don't know the exact number of different law firms that are submitted for possible voting. Nor do I know how they break their tiers down. I just know that there are different law firms who sometimes look at there is the highest level and there's different levels, and we have been awarded the highest level, which is
5 straight years.
Which is a
and it's based on
very
a vote of people out there that use services.
Right.
Well, we always take the callers first before we dive into the show.
Go right ahead.
We've got our first.
That is the show.
Yes, we've got Pablo. It's our first caller today. Hi, Pablo. Are you there?
Yes, I'm here.
Can you hear us?
Yes, I can.
Speak up.
Okay, yeah, you need to speak up a little bit.
Okay, I have a question. I am an owner in a homeowner association governed by 718. Um, I'm having issues with common elements maintenance that has been dragging on and on and on almost for a year now with the association. Communicated repeatedly to the association and to the management company, and while there is limited progress in there, there really isn't any resolution. Um, and what I would like to know is if are there any financial remedies that the homeowner can seek with a homeowner association for it not complying with the Florida statute and its own declaration documents?
Well, you mentioned homeowner association, and then you mentioned 718, which would make it a condominium association.
Sorry, condominium association, absolutely right.
Okay. Basically, you're going to need the assistance of an attorney to accomplish what you're talking about. In order to obtain monetary damages, in essence, you'd have to file a lawsuit against the association for the failure of the board to meet its fiduciary obligation and maintain the common elements in accordance with Florida statutes and your governing documents. And then you'd have to be the prevailing party and be able to demonstrate the damages in the dollar amount that you're talking about. Now, such an action can be brought as a representative, as a class of all the unit owners, and that then the damages would be split among all the unit owners in their pro rata portion. But in essence, you're suing yourselves if you do that. So there is that to keep into consideration. It seems that what you need to be doing, rather than a lawsuit, is perhaps from a political perspective in changing the people on the board who are not making the correct decisions, not undertaking the maintenance that is required within the condominium, if you can. How many units are there?
96.
I'm sorry?
96.
96? Okay, so you would need to achieve a majority of the board and do that through a vote of the owners at the upcoming election. If the board is staggered and you need to change the board quicker, a recall is an option, but you do need to involve the rest of the unit owners, as many like-minded as you can, to accomplish from that perspective. So your options are to get a lawyer, bring a lawsuit, or do it through the political process and change the board.
So I'm aware of those steps, but I'm specifically asking, so just like the association has a tool at its disposal in which it's able to levy fines for owners that don't comply with the documents, am I right in understanding that there is no such tool at the disposal of the homeowner short of filing lawsuit with the association?
Yes, correct. The only monetary damage in the statute is for failure to provide access to the official records, and that would be up to $500 or actual damages, whichever is more, but typically the $500 is the extent of it, and that still requires legal action to make it an obligation of the association.
I see. Okay, thank you very much.
Thanks,
Hi, Pablo.
Pablo.
Thanks for calling.
So let's go to our next call. Great name. Steve.
Steve.
Hi, Steve.
Yes.
Yeah, thanks for holding.
You're welcome. I'm hoping you can help me out here. I live in a co-op that has 40 units, a budget of $400,000. For the last several years, we've had our board treasurer receiving payment for services that, from the best I can tell, are from a DBPR pamphlet, performs the duties and functions of what a community association manager would do. So they're being paid for being a CAM, and they're also the treasurer, but they're unlicensed. And I was wondering what your view of the possibility of a claim to get the monies paid for services for the board paying a board member for unlicensed activity. Can you help me with that?
Licensing requirements for individuals are overseen by the Department of Professional Business Regulation, and you can file a complaint with the department for the unlicensed practice of the individual and as to the association for using such services. Also, paying the treasurer in his or her role as officer and director of the association would not be appropriate unless the documents allow for it or the owners have voted to have that occur. So those are two avenues of pursuit. The Division of Condominium undertakes enforcement of various aspects as well relative to the cooperative association, and you can file a complaint with the Fort Lauderdale office of the division to investigate the financial improprieties. They would not look at the licensing issue directly. That would go to the department, but the division would look at the inappropriate use of the association funds.
Just a quick follow-up on that. Assuming the DBPR says there was some wrongdoing in the inappropriate salary or activity of that as an unlicensed professional, could I go forward with that claim and try and get the money back on a restitution basis, or is it just kind of dead ends there?
Well, that's a little more complicated because services were provided, so it becomes an issue of whether or not it was a reasonable value for the services that were performed, and that can run into a time-consuming and expensive litigation. Certainly, you can pursue it. It's hard to really predict how that would come out, and there's a lot of facts and circumstances that would have to be looked at to give you a more complete answer on that.
Awesome. Thank you very much. Appreciate your time.
Thanks, Steve, for holding.
Good luck with it.
Hey, we got another call.
Thanks.
Let's go to John. John, thanks for holding.
Thank you for taking my call. Quick question. Our HOA, they're doing things that are identified as not being allowed within the community. And I was wondering if there is a state department that oversees the activities of boards.
Hi, John. The answer to your question is generally no. The Department of Business and Professional Regulations, the Division of Condominium Cooperatives and Mobile Homes, has very limited jurisdiction over homeowner associations governed under Chapter 720. That jurisdiction is limited to election issues and recall issues, the flip side of elections. So if it's an issue outside of that purview, then it would require the owner or group of owners to probably start with making a demand upon the board for action, and if they're not getting action, looking to retain counsel who understands this area, give guidance and bring legal action to get change. This is similar to the first question we had with Pablo. If not through legal action, then the alternative would be through the political avenue, through your election or a recall of the board.
I fully understand. You answered my question. Thank you very much.
You're
Thanks,
welcome.
John.
Thank you.
Thanks, John.
Who's next?
Mary.
Mary. Good
John and
morning.
Mary. This is very biblical today.
Good afternoon, Mary.
Yeah, John and Mary.
Hi. This is in regards to HOA and 720 and elections. And before going into anything with the Department of Business and Professional Regulations, there's a couple of issues. One, a recall was going on prior to the election, which is coming up in March, a few weeks. And the law states that recalls have to stop 60 days before there's a moratorium, an election.
Correct.
And not continue until 60 days after. My question is, can that recall that was going on and then the moratorium period of essentially 120 days, can it pick up where it left off, or do we have to start a new recall?
No. If from the facts you presented, the recall agreements are being collected, but they haven't been served on the board, correct?
That's correct.
Right. So it's just an ongoing process. So you can continue. The homeowners can continue to collect recall documents during this 120-day window. You just can't serve them on the board until after the 60 days beyond the election.
Okay, good.
To my knowledge, there is nothing that precludes an owner from signing a recall agreement during that 60-day period. The recall just cannot be effective until after the 60 days.
Okay.
Do you have a
And
different opinion?
Another, if you don't mind, a couple questions.
Sure, go ahead.
With they're thinking about having, people are thinking about having a boycott, okay? Now, a boycott would, in our documents, say, we have to have so many proxies in or so many people in, but it doesn't, I don't know how many people to reach a quorum, because if we don't have a quorum, then the election
doesn't occur.
Doesn't exist. It fails.
Right. Well,
do you know by law what the quorum is?
Like, what we can tell you is that we can tell you that Chapter 720 says the following with regard to quorum of a membership meeting in a homeowner association. Quorum requirement will be 30% of all eligible voters unless a lower number or percentage is set forth in your governing documents. So you'd have to look to your governing documents and see if it's less than 30%. If it's not, if it's more than 30%, then it would reduce to 30. If it's 30, obviously it stays at 30. But if it's a lower number, you go with the lower number.
So look in your bylaws for that information, Mary.
Typically, your bylaws is where you'll find it.
I haven't gotten to that point yet. I was going to, because I've been looking at the statutes and okay. Another thing, this fellow, let's call him John. Okay, he wants to run, and they have refused to put him on the ballot, and without documenting it in any paperwork, saying that he is not an owner, which is a requirement, okay? Now, he and his wife own the property outright without a mortgage, okay? It's already, paid for and everything. And the wife's name is on the deed. Now, the state of Florida, if they're husband and wife, and just the wife's name's on the deed, the husband is still an owner.
No,
Am
he's
I
not.
correct?
No. Record title owner. And if he's not a record title owner, then under the provision you've referenced, he would not be qualified to serve on the board unless the bylaws allowed that. There are some communities that we represent, for example, who will have the title owner and a spouse of the title owner is able to run. But in the way you've explained it, no, he would need to have his name put on the deed, even if it was just a 1% owner on the deed, in order for him to be eligible to run for the board or serve on the board.
Okay.
Now, he does have an interest in the property for estate tax purposes, but for the perspective of ownership to qualify to serve on the board, he would not.
Okay. I do have a suggestion for, I guess it's Pablo, and maybe somebody else brought up the issue of homeowners or condo associations not doing what they're supposed to be doing.
Mm-hmm.
Sure.
What you can do is you can call Broward County and/or the city you're living in, and/or it's a good idea to check the ordinance ahead of time, but call the department that enforces ordinances. And they will have an inspector come out, and they will send whatever violations are in existence according to the city or the county, and send that to the board of directors and say, you have to fix these violations within such a period of time and 21 days or whatever.
Or be fined, and that is a good option if the issue involved does reach the level of being a code violation. If it doesn't, then
Thanks, Mary.
That might not work. I think we need to
go to
Thank
break.
you, Mary. I think we do need to go to break, though.
Okay, we're going to go to break, and I think we've got somebody holding.
So please keep holding.
Yeah, stay there. We'll be right back.
We should have.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert K., Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
We'll come back.
We're back. The Ask the Expert show. And you know what? I want to tell you, first of all, we're on 95.3 FM and 1470 AM. If you have a question for Michael or Robert, 888-565-1470. It's 888-565-1470. You could actually watch the show right now by going to kbrlegal.com.
Yes, we haven't even given that website out yet. kbrlegal.com.
We've got stuff we haven't even got to, but
Let's
we
talk
don't
to
ever want to
Miguel
hold
first.
anybody. So we'll go to Miguel. Hi, Miguel.
You still there?
Yes?
Miguel?
Miguel didn't want to wait.
Okay.
Call back if you'd like. We're here for a little while.
Okay. So tell her, your firm, we haven't even talked about your firm.
Well, I think people are starting to know a little bit about our firm.
Can't you see we have new people every month? that are
Community
tuning in.
association law is the area that we work. We have been providing continuous legal services in our firm for 26 years, and we represent in our two offices in Pompano Beach and Palm Beach Gardens in excess of 1,000 communities and growing. Appreciate all of that. We provide services across the board for association-type matters, covenant review, collection of unpaid assessments, negotiations with contractors, dealing with litigation and covenant violations or with outside vendors, bankruptcy issues that often come up, basically across the board, legal services for everyday association operations.
One thing I've learned from doing,
Miguel is back. Let's pause and talk to Miguel.
Okay, Miguel, can you hear us?
Hey, Miguel.
Okay, what is your question?
Thank you so much for being so pleasant on the. It's very difficult, but it's well worth it because there is information here as pertains to the homeowners equity conversion mortgage and gated communities. I was wondering, does this apply very often in your firm? I don't know. It's rather recent. These reverse mortgages are now available everywhere, and mine is due in 2092, and it's a gated community. It's down in South Dade, and it's there's no walls around it. There should be, but it's very pleasant to listen to you. And I'm thinking maybe you could say ahead as to when I get this hurricane damage and who was the first provider, the bank or the association? I'm not sure. Do you know?
The first provider, you kind of broke up at the beginning, so I'm not sure what you're asking.
The homeowners equity conversion mortgages, reverse mortgages in gated communities.
He has a reverse mortgage.
No, I think he's talking about something else.
Say that and sound very, very good at what you do.
Right, but Miguel, what we're trying to ascertain is ask the question first, then we'll backtrack into the facts we need.
Yeah, there might be no case law, but the question is, when there's hurricane damage, who was the first provider, the bank or the association?
Okay, when you say first provider, that's the clarification we need. First provider of what?
Of the damage.
You mean
From
who's
9/11.
responsible for repairs?
Well, there's a golf course. There's a gated community. There's me here for 60 years. There's worse damage and flooding and cars underwater than Andrew. The trees are still damaging the roofs and the screen and patios, and it doesn't look like they're ever going to be fixed with blue tarps on the roofs and everything. So, but my bank gave me a reverse mortgage due in 2092. So would that homeowners insurance have priority over the association's insurance?
Okay. Again, I just want to be clear, because when you're saying priority as in they get some benefit first. And are we talking about, well, because if we're talking about there's damage there and there should then be insurance claims being filed, under the hurricane damage provisions, windstorm coverage, you independently in an HOA, in a gated community, a single family home, you'll have windstorm coverage for property that you're responsible for. The association hopefully has windstorm coverage for the property it's responsible for. Claims should be filed by both, adjusters coming in for both, and then whatever proceeds are received, you would use to cover the damage. So in your case, your homeowner's insurance would cover whatever it's supposed to cover, hopefully. The association goes for whatever it's supposed to cover. There's a very large deductible, as you're aware of, when it comes to windstorm coverage. So in case of the association, they're going to get whatever money they can get back. The deductible and any other uncovered claims would become the responsibility of all the owners to share in accordance with the governing documents. Does that address the question?
I'm trying to prevent a huge civil lawsuit because this redwood tree, at least 200 years old or more, I've got 6 200-year-old trees around my house that was here. So what I'm talking about is like an educated guess on your part, being the nostrum of you would be the nearest one to ask, even though it's only, say, guesswork, that these trees were here 200 years ago. So if one fell on my roof and destroyed my car and destroyed my roof, I could probably win a lawsuit, is what I was told by a law firm. And these guys they only use case law.
Okay.
So I think if you're on the radio, the state of Florida legislature is not the brightest bulb in the room, so this is a very strange situation. There's 100-year floods and things. And
yep.
200-year-old trees that were here before, that were here 200 years ago. So who would, as far as title searches, I would win the case, wouldn't I?
Again, I mean, it's very fact specific, so I'm going to speak more generally. As far as trees, now, if the trees are located on common property, fall from common property onto your lot, my understanding of Florida law, and Robert can piggyback if he feels differently, my understanding of Florida law when it comes to trees is so in that scenario, the association is not going to necessarily have responsibility for the damage that was causing your property. Your homeowner coverage would cover that damage. The association would have responsibility for anything that occurred on their property, unless there was some way of proving that there was negligence in maintaining, which in part caused the damage. With a windstorm event like that, it's hard to be able to show that. If the trees were on your property, even though they were there before your property was built, then the responsibility would be solely yours.
Okay, but see, I'm not trying to rain on your parade, but there's case law about trees that are so huge they go over a neighbor's house and damage the neighbor's house. Now, wouldn't that apply to me?
Well, again, listen, I'm just going to tell you, the case law that I'm aware of with regard to trees is if there's a tree on your neighbor's property, and by the way, this recently happened, in with regard to Irma, this is going on. So a tree that from a neighbor's property falls on from one neighbor to the other, the neighbor's property that the tree landed on doesn't necessarily have a claim against the first neighbor when the wind, it was a windstorm event, an act of God, if you will. It's different than if there's a failure to maintain.
The neighbor had to pay the other neighbor in every case that I was able to look up in the register.
Okay, well then you have your answer.
Well, I don't know. I mean, I'm just saying it's not very intelligent.
Well, it's not my understanding of the cases that I've seen. I'm just saying so. But obviously, if you have a law firm that says you'll win a case, then let them do it on contingency.
No, I'm just wondering if an intelligent judge would rule on the behalf of, where instead of a neighbor in a golf course, it would be the common elements in the neighbor.
I can't make any prediction with any degree of accuracy there.
Would you be willing to take it on?
No, it's not a case that we would take on.
Oh, it's like the neighbor would be the common elements.
No.
Well,
Because it's growing. These trees were here 250 years ago, and even though it's behind my wall, within 1 inch of the wall is the rule. When you have these gated communities, they have in the rear of the house, they have like a wall around it.
Mm-hmm.
So within the roots are way without 20 feet outside the wall. So normally I would have to repair the wall, but I wouldn't have to. Then I wouldn't have to pay $4,000 to remove the tree, which is crazy. I mean, these trees are huge. And
we got to go to a hard break.
Oh.
Yeah, it's terrible.
Good luck with that, Miguel. And like you said, you mentioned a law firm says you have a good case. Well, it sounds like there's the ones you should be following up with.
No, I've been around too long to think any one thing would work. I've been to like 30 or 40.
Okay, we got a hard break we got to go to. Thanks,
Good
Miguel.
luck, Miguel.
Hey, Brian, hang on there. We'll come right back to you. Let's go to break.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert K., Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
We are back with more Ask the Experts. Phone lines are ringing off the wall. We do have a line open at 888-565-1470. This is the K. Bender Rembaum Hour. If you have a question, again, our phone number here is 888-565-1470. Let's go to our next caller, Brian. Hi, Brian.
Thank you, gentlemen, for taking my call. Oh, thank you, gentlemen, for taking my call.
Sure.
I have a what's probably a very simple question, but we have a 12-member association, 12 townhomes, and we're having a little trouble putting together a meeting where all the homeowners can attend. And the question is, I asked the advice of one of our owners who happens to be an attorney. He looked at our documents and he said that to make most decisions, we only need a 20% quorum. It seems that would be, to me, obviously when we have our annual meeting, we'd like everyone to be there and everyone to have access to the information and the decisions. But are there any Florida statutes that determine, A, what a quorum is for a townhome community of 12, and B, are there certain items that need a full attendance or a higher quorum to make decisions, such as budgetary decisions or elections? Could you help me with those questions?
Sure. And I'm assuming you're a homeowner association, as you've described it, so that's Chapter 720, provides that a quorum is the lesser of 30% or what your documents say. So your documents, you've indicated, say 20%. So that's the quorum for a member meeting at your association, which is in essence 3 homes. Now, the higher quorum requirement would be in your documents themselves as it relates to specific issues, such as amending the declaration. probably has a provision of a majority or 2/3 or some other higher number, which you would need to get for that purpose. The election of directors falls under the same quorum of 20%. Three homes can elect your board if no one else can come. Although you are allowed to use proxies for those who cannot come, so their voices can be heard.
That's usually what we do. If people
And
can't
the budget,
attend,
the budget is typically a board action without a membership vote, unless your documents require somehow that the members approve the budget after the board has submitted it.
But even then, it's still a board decision.
Right. But typically, you don't need membership approval for your budget.
Okay. Well, that answers my questions. Excellent. Thank
Okay.
you very much for serving the community with your hour on the radio. I appreciate all the help. And
go to our website at
again.
kbrlegal.com. You can get more free education.
Oh, is that right?
Yes, there's plenty of it. kbrlegal.com. And there's a resources tab there where you can read Legal Morsels or Rembaum's Association Roundup, articles that are posted weekly or monthly, or usually I say monthly or quarterly, or more frequently if there's things that come out. And I would encourage you to go in there if you have other issues that might pop up and see if they address your questions.
We also
Terrific.
offer
Thank
free
you very
classes.
All the time.
Which we're getting ready to talk about.
Yeah, so if you keep listening, you'll hear all about our classes. And they're also listed on our website at kbrlegal.com. Classes out of our Pompano Beach office as well as our Palm Beach Gardens office.
That raises one more quick question if you
Sure.
have a moment. I know you're busy. What are the requirements for board members as far as education of the condo or homeowner association regulations or statutes in Florida?
The only requirement that the Florida statutes has for board members, whether you're an HOA, cooperative, or condominium, is that you have you have board certification. There are two ways to go about doing that. The simple way is there is a form that the Department of Business and Professional Regulations has created, and you can go to their website and print it out. And essentially it says that you've read your governing documents and you agree to uphold them and meet your fiduciary duty and obligation as a board member. And by signing that and then giving it to the office secretary, having it part of the official records, you've met your obligation. The alternative, and in my opinion, the recommended approach, whether you you sign the certificate or not, would be to take a division-approved board member education class. One of the classes we provide in both offices in Palm Beach Gardens and Pompano Beach for HOA for all board members, and that usually is a 2 to 3 hour class where you come and get the ABCs, the foundation of being a board member. There's 7 different subject matters that are discussed, and at the conclusion of that education, you leave with great materials as well as a certificate. As far as the written certificate, you have to have, the certification requirement is within 90 days of election or appointment to the board, you must have a certification on file. So if you can take a class within that 90 days, then you should sign the certificate to be in compliance and then get to the first class you can. If you take a class, then that class will be valid for 1 year from before you get elected to the board. So if you're not on the board today and you took a class today and your election is prior to March 1st of 2019, your certification from that class over the next year would also put you in compliance. And once you're in compliance, so long as you don't leave the board, you serve uninterrupted, you do not need to get certification again. Although, again, we teach classes all the time, continue to get that free education.
When is the next class?
So does that answers that question, Brian?
Yeah, that preempts that. You already preempted several lead-on questions there. One last thing about directors and officers insurance. Do most insurance companies require that the board members be certified?
Well, it's a statutory requirement, so in order to qualify to be on the board, you'd have to be. So,
okay.
If you don't have your certification requirement in order, once it's brought to the attention of the board, you would have to immediately vacate your seat.
Automatic
Vacating of your seat. In this case, it's temporary. Once you come into compliance, you get your seat back. Even if it was temporarily filled, then the temporary replacement would step down. You'd get your seat back. So obviously, once it's brought to your attention, you're not in compliance, someone can simply sign that certificate and be in compliance. But again,
get certified through
take the division-approved class. And where are you located? Where's your community?
We're in Hillsborough Beach.
Okay, so you're in between. We a little
closer to
Pompano.
Pompano.
Yeah, well, right now the next HOA board class that's going to be in Broward County that we'll be providing is actually not till June, and that will be in Tamarack. Our Palm Beach Gardens office is going to be doing a class March 14th, HOA board member certification. Our next HOA board certification in Pompano Beach, which really is in your backyard a little bit more, will likely either be in April or May. Actually, it'll be in May. It won't be in April. It won't be before May.
Okay, terrific. I'll look for it on the website.
Great.
Thank you, Brian.
Thank you very much.
Thanks, gentlemen.
Okay.
Appreciate your help with the
That's a
community.
good call.
Appreciate it. All right.
Great.
Okay.
So should we
you
talk
got-
a little bit about
Yeah,
this?
you got a lot of classes coming up.
We do. Well, let's start with this. Robert and I, as you know, have done our Ask the Attorneys. It's our 10th year of doing them, and we have one Ask the Attorneys program left.
For
which
this
is
year.
For this season.
This season, yes. And the season typically starts in November, and usually Tamaracks our kickoff in November, and it ends in March, sometimes April, early April. But this year we're ending in March. It's next Tuesday, March 6th. We're going to be at Sugar Sands Park in Boca Raton. It's an evening program, starts at 6:45 p.m., 300 South Military Trail. And this is for those who are listening or are not familiar, this Ask the Attorneys is exactly that. We don't have a set agenda. Other classes I'm going to talk about in a few minutes, the agenda is set. It's a specific class. You come, there's materials on the class, and you learn about a specific topic or subject matter. Ask the Attorneys' agenda is set by our attendees. They come out to the program, they bring their questions, they bring their topics, and Robert and I spend 2.5 hours talking about all different topics and expanding upon them, and it's worked out great. We really enjoy doing it. The response has been very positive.
You'll have more than one question
Yeah.
before the night's up.
The response has been very positive, and so we encourage everyone to come out Tuesday, March 6th, 6:45 p.m. start at Sugar Sands Park, 300 South Military Trail in Boca Raton. There's an RSVP and you can go to the website to get that information at kbrlegal.com. Again, that's next Tuesday, March 6th. Last one until at least November. We then will be doing expos. The expos that we are happy to go every year. We have a booth set at each of these expos. We invite people to come visit us in the exhibit hall. They can come and if you're a client of ours, we love to say hello. If you're considering adding counsel or changing counsel, come speak with us. There's obviously no charge, no obligation to do so. And there's going to be one in April 4th will be in Miami at the James L. Knight Center. April 10th is in Palm Beach at the Palm Beach County Convention Center. And April 24th is in Broward at the Broward County Convention Center. We're teaching classes at all three. I'll be giving the legal update, which is the 2017 legislative changes. And of course, at that point, we'll be able to talk about what bills have passed and are going to the governor for 2018, if any. And we'll also be doing some other education at these classes, at these expos as well. And so we encourage everyone to come out to those expos. And again, go to our website. The classes being presented there are enforcing your covenants, updating your documents. One of our attorneys, Lisa McGill, will be teaching a class on funding construction projects, which is vital, whether you're taking loans from a lender or doing special assessments. It's a great class, and we encourage that you guys come out and come to the education we're offering and then come by the booth, say hello. And if you go to our website, there's a way that you can sign up and register for these expos with using KBR's information, and lunch will be on us as well.
And April 4th is before our next show, so we won't be talking about it again.
That's
true. Right.
That one's down in Miami. Again, kbrlegal.com is where you can get information on all these programs. You can email at info at kbrlegal.com about any of the programs. If you want to RSVP for the Ask the Attorneys or any of our classes, go to the website. It tells you how to do that. There's phone numbers to call, 800 974 0680, 800 974 0680, or go to kbrlegal.com, register that way. And again, and that's a great resource. And it's a great resource, the website. So we encourage everyone to go there. So
And look, if you haven't figured out by now, don't try to handle this yourself. Get a legal counsel like Kay Bender Rimbaum to represent you. What is the phone number if they'd like to call up and schedule an appointment with you?
800 974-0680, or email us at info at kbrlegal.com. Let us know the name of your community and phone number or contact information, and I'll be happy to reach back out to you. And as Steve said, it's no charge, no obligation to sit down and talk about the issues that you're having, talk a little bit more about who we are, and see if it's a good fit to help for us to help the community and the board with the legal issues of the association. We're happy to do that.
Okay. We're going to go to our last break. If you'd like to call us, we've still got some time left. 888-565-1470. That's 888-565-1470. We have time to take your call. We come back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert K., Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size, and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
We're back with our final segment for today. We will be back next week with more experts. If you'd like to call us right now, we definitely have some time. 888-565-1470. 888-565-1470. We started putting things on our Twitter, on our Facebook about our shows, and we're starting to get questions, and we actually had 3 I think are good questions that maybe you can answer. The first one is, our community associations' legal documents are very weak. How can one revise community association governing documents?
Well, these documents typically will have a provision in it that indicates a vote percentage of the interested parties, typically the owners within there, of how many it would take to amend or change them. The first step in any change process would be to contact experienced counsel and have them evaluated. In fact, on Tuesday, March 20th, in our Pompano Beach office, we have a class that we're providing for free called Jumping into the Present, Why Updating the Governing Documents of Your Association is Critically Important.
Wow, you're kidding.
That's Tuesday, March 20th from 6:30 to 7:30 in our Pompano Beach office. There is manager credit in it as well.
So managers should bring out the board members, everyone gets education, and the managers get a free credit.
Okay.
And you would need to sign up for that in advance because space is limited, but it is the type of course that is certainly highly recommended. Once the documents have been evaluated, reviewed, and suggestions made, as well as input from the board as to what issues they'd want to attack, then changes can be drafted by the attorney and then presented to the owners for their ultimate approval. And once,
don't try to do this yourself, right?
It's not a good idea, no. And even those who have property managers, sometimes they try to do it. It's not recommended for individuals or property managers to do that. It is a legal document that is very technical, that's being recorded in the public record. It affects real property, and it needs to be precise in the way it's prepared. So it's important that be done by the right individual.
Okay. Next question is, does the Board of Administration of a condominium association have an obligation to respond to a written inquiry filed by certified mail by a unit owner?
Well, Florida Statutes Chapter 718, which is what governs the condominiums, the Condominium Act, has language that's specific to this question. If a unit owner submits a written inquiry by certified mail, the obligation of the board to respond to that written inquiry within 30 days with a substantive response. Now, if the board is going to refer that matter to their attorney for legal guidance or a legal opinion, the statute then allows the response to be provided within 60 days of the receipt of the original notice. If the board reaches out to the division, then there's additional 10 days from the 30 to get, I believe. Ultimately, that is the response. So if a board does receive a written inquiry by certified mail, they should reach out to their legal counsel to ensure that the responses that they're giving are limited to responding to what the questions are and not giving information that should otherwise not be given, whether it's privileged, confidential, or just otherwise non-responsive, and could unnecessarily expose them. And that's a good idea. And like I said, and with the request for legal guidance, then you have up to 60 days to respond. If you fail to respond to a written inquiry that has been submitted by certified mail, what the law says as the punishment, if you will, quote unquote, to the association is, should an owner make a written inquiry and then ultimately there's legal action that is brought on the basis of what the legal inquiry was requesting, and the association still prevails, where the other association would normally be in position to collect their attorney's fees back from the owner, that would now be waived. So it's important to respond to written inquiries if they're received by certified mail within the time frame provided by statute.
And do it through your legal counsel.
It's always recommended when you get a written inquiry by certified mail that you at least ask for advice of counsel.
Okay. Last question is, I'm a unit owner in a condominium, and I'm having trouble getting my condominium association to answer my questions. I've left numerous phone messages. How can I get them to answer my question?
See the prior answer. Basically, I think that's essentially the way that got presented. Obviously, if you're making phone calls and they're not getting responded to, write a certified letter of inquiry to your association requesting answers, and hopefully they will then respond in the time frame within which they're supposed to. If you're still not getting answers, then as some of our earlier callers we discussed, you'd either need to address things politically by getting, if enough people are like-minded as you in the community feel like they're not getting communication, or you might need to hire an attorney and bring independent legal action if there's proper basis to do so.
Where did you say the it's going to be held at the James Knight Center at the Hyatt Regency?
Correct.
That's on April the 4th.
April 4th.
10:30 to 3 p.m. What is that, the expo?
That's the expo in Miami that we're going to be teaching 2 classes. We're going to be doing guest restrictions, I believe, and the legal update. But the next big program for us is next Tuesday, March 6th at Sugar Sands Park in Boca Raton. That is when we will be doing our last Ask the Attorneys of the 2017-2018 season. And Robert has our class schedule he's going to go over for the 2 offices in Palm Beach.
We're getting a lot of calls from Coral Gables today.
Oh.
Well, on Tuesday, March 13th at 6:30 is a class on covenant enforcement.
Where?
Which at the Pompano Beach office. It also has manager credit, does it not?
All of them do, yep.
Yep. Okay, so that's covenant enforcement. That goes over all the ins and outs that boards deal with on enforcing their documents and dealing with owners who are in violation. In our Palm Beach Gardens office on Wednesday the 14th is the Homeowner Association Board Member Certification course. And on Wednesday, March 21st, is the Condominium Association Board Member Certification course. Both of those start at 6 p.m. and run till 8:30. Space is limited, so it is recommended that you RSVP. You can contact Tricia at kbrlegal.com in order to register for the Palm Beach Gardens programs on either March the 14th or March the 21st.
Okay. So we're coming towards the end of our show, and I always save that because I love listening how you guys do this. Tell people out there why they should retain your firm. Who gets to do it today?
Oh, look, we got a phone call. Well, should we take the call before I answer that question?
Service.
Well,
that's a good
right.
answer.
See, and there's your reason, because a call comes in, and that's important.
Yes.
Customer service, accessibility, and responsiveness.
And let me give you Robert's home phone number after 12 midnight if you thought of a question. Okay, we've got Laura on the phone.
Hi, Laura. Close us out.
Hello. I am wondering who supervises the elections if all current directors' terms are expiring on the election day, and if all of them plus 4 new candidates are running for re-election. How does that work?
Well, generally, elections are overseen by the outgoing board, regardless of whether their terms are expiring or not. They don't expire until the meeting's over, so they're technically still in place until that has occurred. Quite often, they'll have a committee of volunteers from the community to participate.
Well, they're not going to do it.
Right, but they'll be involved in the overseeing. But generally speaking, the existing board, whoever's there that sets up the meeting, handles it until it's concluded, and then turns over the reins to the successors.
Yeah, there'd be usually they appoint an inspector of the elections, which is volunteers, as Robert mentioned from the audience, and this independent committee then will oversee the actual voting, the actual tallying of the process. In a condominium setting, there's verification of outer envelopes that they do, and then there's the tallying of the ballots. It is recommended to have legal counsel come to these annual meetings when there are going to be elections to ensure the processes are being followed appropriately so as to avoid the unnecessary need for expenses after the fact when there are if there are challenges made to the election. It's a lot easier if you have someone there, especially when you have a contested election. The owners don't want to see the current board being involved at all. They want to have an outside or independent person, and sometimes that could certainly be management if there's management involved. But it's always good to have the lawyer present to assist and answer legal questions and let the independent volunteers run the overall process.
Okay, great. Thank you.
Thanks, Laura.
Bye.
Okay, so we were talking about service.
Sure. And well, listen, for everyone listening, you're either serving on your boards, interested in being on your boards, or an interested owner, and kudos to you for doing that. When you live in, I happen to live in a community myself, in a homeowner association, and they're my friends and my neighbors. But it also is, these are all businesses. These community associations, no matter how big or small, are businesses. And some budgets might be small, but other budgets can be quite large. And so when you move into a community, this is what I tell people. When you move into a community, you're signing a contract, and that contract is your covenants, declaration of condominium, declaration of covenants, or perhaps in a cooperative, it's your articles, bylaws, and your proprietary lease. But you have that responsibility as an owner to make sure you pay your maintenance timely and follow all rules, regulations, restrictions, and otherwise just be a good person in the community. Once you decide to volunteer and step up to serve on your board, you have this enhanced fiduciary duty. And now you have to do what's in the best interest of the community.
They're playing you out.
It's only 5:56. You shortened me 4 minutes. All right. So
After commercial.
When you're running your business, you need experts to assist. We come in as your legal expert, and we offer guidance to the board. We have the expertise to do so, and we have the customer service aspect, accessibility, responsiveness, and the ability to provide opinions in English, not nickel and dime.
Quickly.
If you need good legal counsel, contact us at 800-974-0680 or kbrlegal.com. Free consultations available.
And talk to us next month.
Yeah, both Robert and Michael, first Thursday of the month, every month. We'll see you next week. Thanks, guys.
Thank you.
Thanks for tuning in today to the Ask the Experts show. Tune in while some of the top local experts in their field from Broward and Palm Beach counties educate you in the areas of law, health, financial, and home improvement. You can also call our offices at 888-574-6999 to become an expert on our show. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors.